All right, good afternoon and welcome everyone. This is the December 4, 2020 meeting of the Hillsborough County Land Use Appeals Board. Richard Harrison, the chair of the board. As we always do, we'll begin with introductions and go over the rules. We're doing this meeting somewhat live and somewhat virtually, so they'll be different places. Board members who are present live at the meeting today are the Vice Chair, Ricky Bauman, and board members Jerry Campbell, Bradley Cornelius, and Peter Schwartz. Board member Larry Smith is appearing virtually. And we also have with us from Hillsborough County staff, Mr. Tom Hisney, Development Services staff, Sonia Rodriguez, Manager of Citizens Board Support, and our Assistant County Attorney, Cameron Clark, is also appearing virtually at this meeting. I will read the rules that govern these proceedings, and then we will get to our agenda straight away. This board is an appellate body and shall only consider the land use hearing officer's decision and the record. This hearing shall be limited to the record on appeal as defined in Land Development Code, section 10.03.03H, and consist only of limited oral argument based upon said record. No additional evidence may be submitted or considered by board members. The order of presentation will be as follows: staff's introduction, then the petitioner's case, the opposition case, and any rebuttal. Only the following have standing to appeal or to intervene in an appeal which is filed or may be heard at this hearing. Those are the applicant, the administrator, and any person or entity which appeared before the LUHO and presented testimony or other evidence or presented evidence themselves or by proxy the LUHO and was adversely affected by the decision of the LUHO. The board reserves the right to limit presentations to 10 minutes per side. The boards will have the authority to uphold the land use hearing officer's decision or to remand the case back to the land use hearing officer. If the board remands a case back to the land use hearing officer, the board shall specify the reason for the remand and specify the issues for the land use hearing officer to address. The board reserves the right to pose questions to staff, the petitioner, or opposition at any time. The decision of the board will be rendered at the conclusion of this hearing and shall be reduced to writing. The decision of the board is final, but it may be challenged as authorized by state law by any person with standing. Ms. Rodriguez, however we're going to do that, would you administer the oath to anybody who will be testifying today?
Be two people that will be doing virtually, and as they come up, I will do that. Right now, I will do the ones that are present. All raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated.
All right, and with that, let's call our first case, please.
This is appeal number APP 20-1235. The petition file number is special use 19-1026. The appellant is Palm Grove LLC. The property owner is Palm Grove LLC. The representative is Cammie Corbett and Hill Ward Henderson, PA. The petition request is to appeal the decision of the zoning hearing master who approved a special use for a land excavation permit. However, the approval retains condition number 2 as a condition of approval. The location is 15110 Balm, Wimauma Road. The size of the property is 177.62 acres, more or less. The existing zoning is PD 18-0304. The future land use is RP-2. Service area is rural, and the date of the zoning hearing master was August 3rd, 2020.
All right, as we always do, let's hear first from staff on this case.
Good afternoon. In the subject case, as noted by Sonia, there was an application for a special use permit for a land excavation. This case was heard by the land use hearing officer on August 3rd, 2020, and she approved the special use for the land excavation, subject to the recommended conditions of approval that had been proposed by staff. These conditions, specifically condition number 2, requires that prior to operating permit approval, the applicant shall obtain approval from the Board of County Commissioners of a modification to Plan Development 18-0304 to amend the permitted uses to include a land excavation. The subject property, and I'm sorry, I should have provided a little background. The subject property is part of a planned development district. That planned development has 2 separate parcels in it. This is the parcel that is known as the Grove parcel in the project. The conditions of approval for the planned development for the Grove project permit a maximum of 356 single-family lots, and then there's also a small village node in the middle of the parcel, which is allowed 5,000 square feet of neighborhood retail uses, office uses, residential support uses, and government uses. So those are the uses that are permitted in the Grove parcel. Those uses do not include a land excavation. Therefore, the recommended conditions of approval that were approved by the land use hearing officer require that they attain a modification to the PD to allow a land excavation. The rules for a plan development require that when you want to add uses that are not expressly permitted by that plan development, that you need to get a modification approved by the Board of County Commissioners.
All right, Mr. Hisney, is that type of modification, is that a major modification under the code?
It would be a major mod. The conditions just say modification, but addition of a new use would be a major modification, yes.
All right, very good, thank you. Board members, because we're operating here somewhat differently than we typically do, and I cannot see all of you, I will call, whenever we're going to have questions, whether it's of staff or a witness, I will call on board members one by one. If you have questions, feel free to ask them. If you have no questions, just say you don't have any questions and I'll call on the next person. But I think that's the only way we're going to be able to manage this given the circumstances. So let's start with board member Smith. Mr. Smith, do you have any questions for Mr. Hisney?
No questions at this time.
All right, board member Schwartz, any questions?
No questions.
All right, board member Cornelius, any questions?
Mr. Chairman, I just have one brief question, if I may.
Yes.
Thank you. Mr. Hisney, just out of curiosity, going through the record, why was the county staff's position that the land excavation was a separate use from just the excavation required for the ponds for the subdivision? As I read the record, it appeared to me the excavation was related to I'll say lakes that were part of that subdivision. So that was the part I was a bit confused on, why staff saw that as a separate use as opposed to just implementing the PD.
The size of the pits that were proposed for this excavation greatly exceed what would be needed for, let's say, stormwater management or similar in the project. But specifically, the fact that the PD shows ponds in itself doesn't mean that those ponds would necessarily require a land excavation in order to achieve those ponds. Land excavation is where you remove more than 30,000 cubic yards from the property, and during the time of the PD. Anyway, so you could potentially implement the PD plan and produce those ponds without needing an excavation. But again, additionally, the size of the excavations, and as was acknowledged by the applicant during the hearing, greatly exceeds what would be needed for stormwater management.
Thank you, sir. That helps. I appreciate it. That's all, sir.
All right, Board Member Campbell, any questions for Mr. Hisney?
No questions.
All right, thank you. And Vice Chair Bauman, any questions for Mr. Hisney?
Mr. Hisney, so to remove 2.5 million cubic yards of material over a 5-year period, when would you get that kind of volume? What will we be doing other than a retention pond to require that type of thing? Are we looking at like a lagoon or something like that?
You'd have to ask the applicant that.
Thank you.
All right, I think that's it for board member questions of staff. So at this point, we will hear from the petitioner or the appellant through their representative, Ms. Corbett.
The law firm of Hillsborough and Henderson representing the applicant Balm Grove. And as you've correctly heard this afternoon, although the land use hearing officer approved our application, we are appealing on the basis of
The intro?
Sure. Again, Cammie Corbett with the law firm of Hillsborough Henderson representing the applicant Balm Grove LLC. As has been correctly stated, although the land use hearing officer approved our application, we are appealing that approval on the basis that her decision retains condition 2 from the recommendation of approval by staff. As you heard, the condition requires the applicant to amend its existing PD to add land excavation as a permitted use, even though section 61101 of the Land Development Code clearly states that land excavations can be located in any zoning district. This is a condition that has never been imposed on any other similarly situated permitted special use permit for lake creation. The Equal Protection Clause of the United States Constitution requires that the governmental entities treat similarly situated persons or entities alike. The applicant presented substantial competent evidence in the form of expert witness testimony that in 25 years of collective experience of Mr. Steve Lutz and Mr. Todd Amidon, no similar condition has ever been imposed on any application or special use permit. The applicant also submitted documentary evidence that there have been 183 land excavation cases dating back to the 1970s when no similar condition has ever been imposed. We provided testimony and evidence and supporting the Land Development Code regulations that indicate that special use permits are separate and distinct from zoning approvals. Special use permits are over and above what is approved in the rezoning. Special use permits are also approved through the land use hearing officer, not by the Board of County Commissioners, unless otherwise specified, which I'll talk about in a minute. And also, again, we established that land excavations for lake creation are allowed to be located in any zoning district. By contrast, the special use permit for wireless communication towers expressly include a requirement that if a wireless communication tower is to be located within a PD zoning district, the communication tower has to be a permitted use within the PD. No such indication of any language is included in the land excavation provisions of the Land Development Code. And accordingly, staff's condition to impose such a requirement on this application is tantamount to a Land Development Code amendment, which exceeds the scope of their authority and that of the land use hearing officer. None of the evidence presented by the applicant was refuted by the county. In fact, the testimony provided by Mr. Hisney and Mr. Clark confirmed that neither of them are aware of this type of condition being imposed on any other special use permit that they could recall. And they are both very seasoned professionals who handle special use permits and zoning matters. When the hearing officer asked Mr. Hisney the reasoning for imposing the condition, rather than giving the answer he gave today, or giving her an answer at all, he deferred and introduced a red herring of a procedural issue, saying that this applicant could have applied for a zoning interpretation to figure out staff's rationale behind imposing the condition. This is highly unusual and contrary to the provisions of the Land Development Code that provide that the conditions to the special use permit are subject to review and consideration by the land use hearing officer. The county attorney's office confirmed at the hearing that it was not necessary for the applicant to go through a zoning interpretation before the land use hearing officer could render an opinion on the merits of the issues. However, in the land use hearing officer's decision, she failed to reach a determination on the merits as to whether or not the condition was justified based on the testimony and evidence in the record. It's our position that the failure to do so departs from the essential requirements of the Land Development Code, which require the land use hearing officer to make her decision based on the merits of the substantial competent evidence in the record on the issues presented during the hearing. This unequal treatment of this application by county staff and now by the land use hearing officer results in an unequal application of the Land Development Code on an ad hoc basis and constitutes an intentional and discriminatory exercise of power which is being applied in an irrational and arbitrary manner without any reason or rational basis for the disparate treatment. In addition to the equal protection claims related to the condition, the land use hearing officer's decision also reveals new procedural due process concerns. The land use hearing officer mentioned several times in her decision that due to technical difficulties relating to the remote aspect of the hearing, she was prevented from clearly communicating to the county attorney's office on issues related to the imposition of condition 2. There were certainly technical difficulties that occurred at the hearing, but it was very clear that Mr. Clark opined that the land use hearing officer could make a determination on the merits of whether or not condition 2 was appropriate. However, in item number 8 of the findings of fact, it appears that as the result of the technical difficulties, there was a subsequent conversation with the county attorney's office regarding her questions that appear to have influenced her decision in some manner. To the extent that the land use hearing officer had questions that were not able to be answered on the record because of technical difficulties, the applicant should be entitled to a remand to provide an opportunity to hear the questions and the responses and have the opportunity to provide rebuttal testimony. Failure to provide an opportunity will result in a deprivation of the applicant's procedural due process rights. The entire record in this case makes it clear that this application is being treated in a manner that's clearly different than any other similar situated application, and there has been no rational basis articulated that would explain this treatment. Accordingly, we respectfully request that you remand this case back to the land use hearing officer to conduct further proceedings with respect to the propriety of condition 2 and to cure the procedural defects that occurred as a result of the technical difficulties. And I would submit to you that I understand the Land Use Appeals Board's questions this afternoon. They were not answered on the record, and to the extent that you need additional information, I think that also warrants a remand back to the Land Use Hearing Officer to allow staff to provide that testimony into the record. And with that, we're here to answer any questions.
All right, Ms. Corbett, let me ask you a couple of questions, please. Because I think I heard you raise some points that I didn't really see spelled out anywhere in the record. Are you suggesting that the LUHO had some communication with either staff or the county attorney outside of the context of the land use hearing officer hearing?
That is what it appears to me in finding of fact number 8.
Well, show me where it says that precisely.
Okay. In a note throughout, she mentions the communication problems prevented her from communicating clearly with the county attorney's office. There must be a reason that she's indicating that. And she said,
Well, I see that. I see where the order says that there were communication difficulties. I think you've acknowledged that, and I think that's clear from the
I found it on
record,
page 15.
right?
Of particular note in discussion with the Assistant County Attorney's Office was testimony from the applicant's representative. So that indicates to me that she had a subsequent conversation with the County Attorney's Office. Or it raises the specter that that's the case.
Board members, that's page 1A20 or 21.
1A21. Well, okay, so the reason I'm asking is you're making a very serious charge, and I would expect there to be some clear evidence to back it up. This does not
I
say
don't view
that.
it as a serious charge. I don't think, I think it's a process issue, and I think that the technical difficulties resulted in the need for this, set the land use hearing officer to have the need to speak further with the county attorney's office. The county attorney's office can communicate with staff, county attorney's office on technical matters, but this appears to be a discussion about something that's directly related to the merits, and I don't think anyone did anything, not trying to accuse anyone of impropriety on, that they intended to. I can't tell, but it certainly appears to me that there's a reason why the hearing examiner or hearing officer repeated several times that she had trouble communicating with the county attorney's office. And then there's a reference to a discussion with the county attorney's office that wasn't a discussion that I was privy to. And so that's why we're asking for a remand to allow this to go ahead and go back to hearing to let all of these issues be aired at the hearing. And then that way it can come back to you in that context.
All right, well, I'm still not seeing anything in the order that says whatever discussion that Lujo had with the county attorney was outside of the proceeding. So I'm concerned about that. Did you raise with the Lujo at the hearing the equal protection aspect of this that you are now apparently arguing?
Certainly, although I didn't say the words U.S. Constitution, we certainly presented ample evidence that we were the only application that anyone with any history or knowledge is aware of that has been required to have this condition. I even testified at the hearing that I've been doing land use cases for 15 years for residential subdivisions, and never once have I been asked whether or not the lakes shown in the subdivision will result in an export of more than 30,000 cubic yards of fill. It's just not a question that's asked. It's always been treated historically as not being required to be as a permitted use in the PD. That's how the code has been historically interpreted, and that was again supported by testimony and evidence of just about everybody who spoke in the case.
All right, let me give other board members the opportunity to ask questions, and again, we'll do this one at a time until each board member is done with their questions, and if anything comes up that I think merits further opportunity, we'll maybe have a second round, but let's start with one round of questions and try to get all our questions answered. So let's go first to Board Member Smith.
I have a particular question. When you mention, and I'm addressing the, I forgot your name, who presented this case, but when you presented that you checked back all these years and you never found a similar case where they were required to go back and get a rezoning of a sort of PD. Can you cite in your records there any case that actually included exceeding the 30,000 cubic yards of fill, actually building a lake instead of just ponds associated with the development?
They are included in that list that was submitted into the record.
Does the list show the size of the lake?
No, the list itself would not show the size of the lake.
Well, do you know of any that did exceed the 30,000 cubic yards?
Yes, I'm aware that there are, including the companion rezoning that is associated with this PD. Mr. Hisney talked about the north parcel and the south parcel. There's an existing borrow pit in the northern portion of the parcel, and there's no tick and tie back to the land excavation or whether that's a permitted use in the PD, even though there's a borrow pit in the PD.
Anything else, Mr. Smith?
No, not at this time.
All right, thank you. Board Member Schwartz, any questions?
No, my question was just answered. Thank you.
All right. Board Member Cornelius, any questions?
Mr. Chairman, just one question, please. Ms. Corbett, just getting back to, is there a reason or purpose why the excavation is larger than what would be considered under the PD as part of the site plan? Is there a reason for that over 30,000?
Mr. Lutz testified in the record that because of the topography of the site, because it's higher than average properties, that this will result in more than 30,000 cubic feet.
Thank you. That's all I had, Mr. Chairman.
All right, Board Member Campbell, any questions?
Yes, Ms. Corbett, I just have one question for you. So initially, when they envisioned those ponds or lakes as on the initial PD, approved PD, were you assuming that you would be excavating? And I think initially it was 3.3 million cubic yards, and they scaled it back to 2.5 million cubic yards. That's a lot of dirt. I mean, is that something that they discovered they wanted to do afterwards, or is that something that in their mind was there all along, and in the initial drawings that should have been interpreted by the county as, yeah, that's what they wanted to do?
I will stick to what's in the record, and that is that large lakes were contemplated to be excavated, and yes, the applicant expected that they would exceed the 30,000 cubic feet. Once we go to 30,001 cubic yards or 30,000, and 30,150, the special use permit is required anyway.
Thank you.
All right, Vice Chair Bauman, any questions?
Yes, Mr. Chair. Ms. Corbett, we understand that the normal limit is 30,000 cubic yards. How do we get to 2.5 million? There's no correlation between the two, and I don't see any reason that special application should not have been made for with that type of exception. We're not even talking 10 times. We're talking roughly 100 times the same volume.
Respectfully, that was not something that was, it's a function of the size of the ponds and the depth of the ponds, and that is not a factor to consider with a special use. We follow the criteria that's in the code for a special use permit for a land excavation of this size. And there is no distinction in the code about the size. There's no tiering in the special use permit criteria for land excavations. It doesn't matter how much there's not a criteria where it says, well, if you're over this amount, you have to do this, or if you're over that amount, you have to do that. There's no basis in the land development code for what you're suggesting. The land development code could be amended to do that, where it says that if you have a volume that exceeds something by a factor of another thing, that could be a requirement, but it's not a requirement. And we're allowed to be processed under the standards that are in the land development code. Staff can't just make up and make amendments to the land development code and the criteria based on their opinion as to the volumes, and I don't think staff had any objection to the volumes. In fact, they recommended approval of the special use.
Correct, but they're saying that when you exceeded the $30,000, you needed a land excavation permit. Am I correct?
Once you exceed 30,000 cubic yards, yes, you need to have a special use permit.
Okay, thank you.
Ms. Corbett, what in the PD expressly authorizes the excavation that we're talking about here?
The PD doesn't expressly authorize any special use. We couldn't sell alcoholic beverages. If we had in the village node, we wanted to come back and get a special use permit to put a use that allows that alcoholic beverages or any other type of special use, those aren't shown as permitted uses in the PD. And the only special use where there's a tie back to being required to be in the PD is the wireless communications section.
Okay. And walk us through, just because I want to be sure you get a chance to do it clearly in this record, walk us through the provisions of the Land Development Code that you believe support your argument today.
Direct you to 61101. Which speaks to the locational criteria for land excavations, and it specifically states land excavations may be located in any zoning district.
Which subsection of 6.1101?
As I don't have that right in front of me, I can get it for you.
Provide the correct citation.
Thank you.
Yeah, it's section 61154A1.
Okay, so is this what we're referring to? 6.11.54A1A says lake creations, lake cleaning, and stockpile removal may be considered in all zoning districts?
Yes.
Okay. All right, any other specific provisions of the code that you believe bear on this question that we should be looking at?
I believe all of the code sections cited in the record are relevant to the decision that you're making today.
Well, I'm giving you the opportunity to walk us through them rather than rely on everybody on the board having read the 1,500-page record and correctly ascertained your argument. If you don't want to tell us what your argument is, that's fine.
But it's not a matter of not wanting to tell you. I'll need to go back to my seat and pull out the information from the record real quickly, or provide it on rebuttal, but I do have them for you.
All right.
Just don't have them at the podium with me.
All right. Why don't we then, since we'll certainly allow you rebuttal on this, why don't we hear from the opposition at this point?
I'm sorry, I apologize. We did want to make the point on the record that the size of the lakes on the land excavation, and we can put this on the m.o.l, we can show you the size of the lakes on the PD plan, and then the size of the lakes that are on the land excavation site plan, and they are the same. They match.
You're talking about the size in terms of the horizontal and vertical directions. Does that tell us anything on the PD about the depth or quantity of fill?
It should give a reasonable person the opportunity to understand that there would be significant excavation that would be required.
And what about those drawings would do that?
What about the drawings would do that? If anyone would, I would suspect to say to you, again, we're getting outside of the record, I think, a little bit here, but, and these questions can certainly be addressed in the record if you were to remand it. But I would say a professional engineer could probably take that assessment in terms of the size of the ponds themselves.
Okay. All right, let's go ahead. Let's find out if we have any opposition who want to speak today, and if so, let's hear from the opposition.
I believe we have Buddy Harwell. Mr. Chair, this is Cameron Clark. May I intervene very briefly?
Yes.
Just because the code requires that the Land Use Appeals Board shall determine whether a person or entity has standing to appeal or intervene in an appeal at the appeal hearing. For the record, I believe Mr. Harwell was present at the hearing before the LUHO, and if that could be so stated or confirmed, just as a procedural box to check, if the board could then just acknowledge that he has standing to intervene in the appeal. That's all. Thank you.
All right, let's have staff confirm that for us. And Mr. Clark, we need more volume when you're speaking.
Y'all ready for me?
I believe we're waiting on staff.
Yes, Mr. Harwell participated in hearing. I'm sorry, I didn't realize that the question was being directed to me.
Okay, so Mr. Clark, are we satisfied then that Mr. Harwell has standing to speak today?
Yes, you are.
All right, Mr. Harwell, thank you for letting us clear that up, and the floor is yours, sir.
Thank you.
Mr. Harwell, please stand by. We need to have you and Mr. Franklin take the oath of witness.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right, go ahead, sir.
All right, Buddy Harwell, Balm, Florida, board member of the Balm Civic Association, president of the Concerned Citizens of Gibsonton. I got one question on the optics. The evidence submitted was the whole decision of the previous appeal. So does that open it up to we can talk about the wells, the noise, and all the other stuff, since it was submitted in the evidence?
The only issue that's been appealed in this case is the single issue that the appellants have raised, which has to do with whether or not ESCC approval is required. None of the other conditions of the special use permit or the land use hearing officer order have been appealed by any party. Did you file an appeal in this case?
I tried, and that was my next thing. I tried, but I could not get the county staff to call me back within the 30-day process in order to file my appeal, because the LUHO appeal packet is incomplete, has wrong information, and I have talked to county staff about that. So I did want to make sure that was put on the record, because I was going to file an appeal for the rest of the content of it.
Well, that means you didn't file an appeal, so the only issue that we're considering today is the issue that has been appealed, which is the single issue about whether a modification to the PD is required. So you'll have to limit your comments to that issue.
Okay. Well, first of all, I mean, they have two other options if they didn't like the county's decision. They could have asked for a zoning interpretation, or they can open up a major modification and have the Board of County Commissions decide this, but they didn't. They've known about this option two, or since last August, if not before that, and there is records, paperwork in the records that states that they knew about this, and yet they proceeded and went through trying to get the county, I guess, to change their mind in between. They talked about the 126 other excavations. They couldn't find any proof of them having to open up a PD to do the excavation, but have they produced anything into evidence showing that a PD was planned first and then the excavation afterwards? one excavation that they're talking about that was part of this original PD up on Rodine Road, it was an excavation first and then turned into a PD. So, I mean, that's you know, two separate issues right there. The other thing, the two surveys that they just stuck online, there is a difference between the ponds on those. Originally, the pond was a rectangle, and now it's a square, and then the lower right was a square, and now it's shown rectangle. So which surveys or maps are we going to use for this this meeting? Whatever ones that suits our needs. And like I say, there's a lot of issues with this. I mean, they had the option of going to the county or planning commission to find out the definition long before this came to a loophole. If they didn't like the decision before it went there, that's something they should have got the interpretation before instead of going through this whole other process. And I will turn it over to Mr. Franklin, I guess.
Let me know if I can speak.
All right, Mr. Franklin, did you participate in the LUHO hearing?
Yes, I did.
Staff, have we confirmed that?
Could you repeat that?
Sorry.
Have we confirmed?
Yes, Mr. Franklin did speak at the hearing, yes.
All right, very good. So, Mr. Franklin, go ahead.
Fantastic. I would like to see this go in front of the county commissioners. It seems like they can make the decisions that need to be made. I think that's a fair way to do it. That's what I have to say. Thank you.
All right. Let's see if any board members at this time have questions for Mr. Harwell or Mr. Franklin. Board Member Smith, any questions?
Could you repeat that, Mr. Smith?
No questions.
Thank you. Board Member Schwartz, any questions?
No questions, thank you.
Board Member Cornelius, any questions?
No questions?
Board Member Campbell, any questions?
No questions.
And Vice Chair Bauman, any questions?
No questions. Thank you, Mr. Chair.
All right. Thank you, Mr. Hartwell and Mr. Franklin. Ms. Corbett, you are entitled to rebuttal. So this would be your opportunity to do that rebuttal.
Harrison? Mr. Harrison?
Yes.
Yeah, I don't believe I had a full opportunity to make my presentation to address some points.
Oh, I'm sorry. Did I overlook you, Mr. Hisney?
You kind of started off with me, which I usually follow the applicant. I start with a brief just explanation, then usually the appellant goes, and then it's my opportunity.
All right. Before we do rebuttal,
okay with you, sir.
Yeah, let's go ahead and hear from staff through Mr. Hisney before we do rebuttal. That way, if there's anything that Ms. Corbett wants to address, she will have that opportunity. So, Mr. Hisney, I apologize. You go ahead, sir.
All right, so it's been stated by Ms. Corbett in her presentation today that during the hearing when asked why a modification of the PD was required, that I deflected by stating that, well, they could have requested a zoning interpretation for this matter, but they didn't. I'd like to point out that the record of the hearing, of course, includes the staff report. And in the staff report in section 1.0, I'm going to read the final two paragraphs of that section. It says PD 18-1304 permits the development of a maximum of 356 single-family lots on the subject property, which is identified as the Grove parcel in the PD. The PD site plan shows three, quote, ponds, open spaces, close quote, at the location of the proposed excavation pits. And the plan states there are no proposed man-made water bodies except for retention/detention ponds. The LDC defines land excavation as removal of total quantity of more than 10,000 cubic yards of material from a site or more than a total of 30,000 cubic yards of material for projects with approved subdivision construction plan. Preliminary development plans have been submitted for the subdivision are currently under review by staff. The permitted uses allowed by PD 180304 do not include the proposed land excavation. Therefore, approval or modification of the PD by the Board of County Commissioners will be required prior to operating permit approval for the proposed land excavation per the recommended conditions of approval for the requested special use. So the record is clear as to why a modification is required. Then during testimony, I would also direct you to that while originally when answering the hearing master's question, I did bring up the question of an interpretation of the rules. Later on in the testimony, Mr. Clark asked the question, and I had it marked. Give me 1 second. Okay. Let's see. Did ask the question as asking to me the nature of the condition. What is the reason for condition? And my reply is the condition was put in place because land of excavation was inaudible under the condition. My recollection was that it was not permitted, and you'll find that on page 1.A.65 of your backup, and my response are lines 22 through 24. So the question of why a modification is required is clearly addressed in the staff report and then also in my testimony. With regards to applicable regulations, while it is indeed correct that section 61154A1 of the Land Development Code states that lake creations may be considered in all zoning districts, I also draw to your attention to the part of the code that deals with planned developments in section 5. And so planned developments are unique zoning districts that are regulated by the conditions of approval and the site plan for that particular planned development. Some planned developments are very broad in what's permitted and often make reference to use categories permitted under Euclidean districts. Other planned developments can be extremely restrictive. As I previously stated, this one for the Grove parcel allows single-family homes and then a small so-called village node. And those permitted uses don't include a land excavation. So, the part of the code that deals with planned development, section 5.03.07.3.c states that a major modification for an addition of a use from the specifically approved use is required in a planned development. So, we have two parts of the code addressing the same provision, and they are somewhat in conflict with each other. And this occurs throughout the code. I mean, it's a large, complex document. So the code, though, provides direction on how that's to be resolved. And I direct your attention to section 1.03.04.c of the code, which states that where provisions of the code conflict with each other, the more stringent standard, limitation, or requirement shall govern or prevail. So in this case, the more stringent requirement would be that you need a modification to the plan development. And then I'll conclude my remarks, sir.
All right. Thank you, Mr. Hisney. Let me, because you've given us some new substance, let me see if board members have any questions for you about what you've just explained to us. Board Member Smith, any questions?
No questions.
Board Member Schwartz, any questions?
No questions, thank you.
Board Member Cornelius, any questions?
No questions?
Board Member Campbell, any questions?
No questions.
And Vice Chair Bauman, any questions?
No questions. Thank you, Mr. Chair.
Thank you, and thank you, Mr. Hisney, for that additional information. Now, let's go back to Ms. Corbett for rebuttal.
Cami Corbett, for the record, I am going to object to the testimony that was just given. That is new testimony, not in the record. It relates to things in the record, but it was testimony that was not provided during the hearing at the hearing officer, and I just want to point that out. But going back to the code provisions, I'm relying on specifically sections 5.2.1 special use permit A, indicating that special uses that would not generally be appropriate in zoning districts without compliance to more stringent standards. So it tells you what a special use permit is. Then specifically 61101B, which talks about the special uses contained in this part shall be considered and approved with conditions or denied in accordance with the requirements of 10.0200, which is the land use hearing officer proceedings. And then also, Mr. Hisney correctly pointed out, section 61154A1A is lake creations being considered for locational criteria in all zoning districts. And then also section 61129, which is the wireless communications tower provision of the land development code that specifically requires a communication tower to be an approved use within a PD zoning district. And again, part 10.0200 in terms of the procedure for the proceeding below. And if I could ask Mr. Hisney just a quick question on the existing zoning, is in the northern parcel where there was an existing borrow pit, was that listed as a permitted use within the zoning?
I had not researched that part of the project. The land excavation was in the south parcel, so I don't know.
It was not. Let's submit to you, board members, it was not in the record. If you, the zoning is in the record, and I think you will see there was an active, the record will reflect that there was an active borrow pit on the northern parcel, and there is no reference to it being a permitted use within the PD's district. So again, we are asking, given the fact that we are hearing testimony for the first time from staff on elaborating on the substance of why they made their decision, I think that it in and of itself justifies a remand to have this go back to the land use hearing officer and not have the land use appeal board substituting its judgment for that of the land use hearing officer. And with that, I respectfully request that you remand it back for a hearing.
Don't step away yet. There may be questions. In fact, there will be questions because I have some. What is the specifically approved use of the property in PD 180304?
Property? Properties that are in the PD.
The Grove property is the part we're talking about, right?
Or as Mr. Hisney testified.
Okay. What is the specifically approved use of the property in PD 180304 as to the water bodies, ponds, retention ponds, whatever they end up being, that we're talking about?
As we have testified, as the record reflects, land excavations are not included. Land excavations are a special use, and they are not ever listed as a permitted use except in the case of wireless communication towers. If you had a commercial retail center that was approved, it wouldn't show alcoholic beverage service as a permitted use. You would apply for a special use permit to obtain that. Special uses are separate from zoning. They're over and atop. It's a totally different process approved by a different body. And that's how the Land Development Code has been interpreted historically. Record.
All right, let's see if board members have any questions before we take up our discussion. So let me go through our board members one more time. Board Member Smith, any questions?
No questions.
Board Member Schwartz, any questions?
No questions.
Board Member Cornelius, any questions?
No questions.
Board Member Campbell, any questions?
No questions.
And Vice Chair Bauman, any questions?
One question, Mr. Chair. Ms. Corbett, that code 611 that we keep referring to, doesn't that say may? It doesn't say required, it says may as a possibility, not as a requirement?
It's a locational criteria, and it said, so it's in, where can they be approved? What zoning districts can they be approved in? And it says any. It doesn't mandate that the special use be approved. If, for example, we didn't justify the waivers that we requested, if we didn't demonstrate compliance, otherwise compliance with the rest of the special use criteria, we would not be able to be approved for special use criteria, but we meet all the other criteria, and that was demonstrated through substantial competent evidence in the record and found supportable by both staff and the land use hearing officer. So this is one criteria. We're not saying, it's saying where, you have to look at it in terms of where are they allowed to be considered. And it says any zoning district.
But per the code, it says may, not that it's required, it's a possibility. It can be looked at, it can be permitted, but it doesn't have to be.
Submit to you that the only basis is the location of the zoning district. Yes, it would need to be approved. It could not be a basis for denial.
I don't see where when it says may, that makes it required. I understand shall or will would make it required, but I don't see where may makes it
You have to
mandatory.
apply that locational criteria with the rest of the criteria in the code. So it may be in some instances where it wouldn't be appropriate if it doesn't meet the other criteria, if it doesn't demonstrate satisfaction with all of the other special use permit requirements, then it could not be approved. So just because it's zoning district X doesn't mean that you get out of all of the other requirements that you're required to meet.
Correct. So going back to Mr. Hisley's testimony, where he says when there's conflicts in the code, and that we know that there are, it gets to the higher body, which is the county commissioners.
Submit to you that there is not a conflict in the code. It's never been considered to be a conflict in the code. They testified this exact zoning has a borrow pit on the northern parcel that had an active operating permit, and it's not recognized as a permitted use. Why? Because that's not how the county has ever historically treated land excavation cases. They're treating this case differently in every respect, and the record reflects that.
But the north parcel is not the subject of the hearing, of this hearing. And we don't have...
There was a question about whether or not we had, of the PDs that we talked about, could we cite an example of where there was a PD and an active borrow pit? And we're telling you the same exact zoning, so it is relevant to this decision in terms of whether or not staff's assertion that this particular land excavation application must amend the PD to have it be allowed as a permitted use under the zoning is rebutted by the fact that they don't even have it in the northern parcel for an existing active borrow pit.
But I don't have that in front of me. So I cannot make a decision on something that's not in front of me that I would have had a chance to review prior to the hearing.
I tend to agree with you. I think part of the problem is that we're hearing testimony today in support of staff's decision that wasn't placed into the record below. And that is why that is why we're requesting the remand to allow these issues to be fully aired in the open hearing and discussed and decided.
Thank you, Ms. Corbett.
Ms. Corbett, one more point I want to cover is this sounds like it is, in essence, a question of code interpretation, which would be a legal question. Are there factual disputes anymore? And if there are factual disputes, tell us what they are.
Actual disputes with respect to
anything. If we determine to remand, are we going to remand and tell the hearing officer to reconsider the law, which is the code interpretation, or are we going to specify, because if we remand, we have to specify what we're doing, are we going to remand and say, you need to take further evidence on certain factual questions or factual issues?
It's both factual and legal.
Okay, what are the factual issues?
Factual issues are whether or not this condition has ever been imposed on any other PD. And we still have not heard any testimony or evidence from the county that has been the case. It sounds as though this body has that question in their mind as well. So the factual issues relating to the land excavation and whether or not it was contemplated, and that dovetails into the legal issues as to whether this condition is appropriate for this zoning.
All right, well, whether or not there's ever been anything else like, you presented evidence on that at the Luho hearing, right?
Staff has indicated that we presented at the Luho, we presented it back in September, and staff has each time said that they hadn't had any opportunity to consider it. We're legally entitled to have our information reviewed and have a full hearing on it. Circumventing this way deprives us of the ability to have a full and complete record.
Well, you were not deprived of any opportunity to put on any evidence in front of the Luho, were you?
We were not, but we were deprived of the benefit of staff's answers that they provided to you today.
Okay. All right. Thank you, Ms. Corbett. All right, board members.
Mr. Harrison?
Yes.
May I address Ms. Corbett's comment about introduction of new information at this hearing?
Yes, I think we should hear that.
I'd like to direct your attention to section 100502F of the code, which deals with the conduct of the hearing in front of the Land Use Appeals Board. Paragraph 2 states, in addition to the record on appeal, the land use hearing officer and parties to the appeal may freely refer to the following: applicable portions of the Hillsborough County Comprehensive Plan, the Hillsborough County Land Development Code, and any other duly adopted Hillsborough County ordinances, rules, or resolutions. What I read to you is in the Land Development Code.
Correct, in the Land Development Code, but it was provided in context to a question that was asked at the hearing, and you're giving a different answer than the answer that you gave at the hearing.
All right, Ms. Corbett, we're not going to have you debate the witness on the appeal. Hang on, because I think we have some board member questions. Let me do one more round of all our board members, and then we're going to move to discussion. So, last round of questions. Mr. Smith, any questions?
No questions.
Board member Schwartz, any questions?
No questions.
Board member Cornelius, any questions?
No questions, sir.
Board member Campbell, any questions?
Yes, I had a question, but it's not of Ms. Corbett, it's of Cameron Clark. So does that come later?
Let's wait,
Sure.
because I'm going to get some input from Mr. Clark on this as well.
Okay.
Vice Chair Bauman, any further questions?
No questions, thank you, Mr. Chair.
All right. Board member Campbell, go ahead and ask your question of Mr. Clark, and let's see where that gets us.
Okay, Mr. Clark, there was a comment made earlier at this hearing that you had outside communications with Luho as it pertains to this particular process. It was outside communications outside the hearing process itself. Is that true, or is that just maybe a misunderstanding?
Sure, I'll speak to that. First of all, though, just be advised that I'm not a party to the application. I'm not part of the opposition or even with staff on this. I sit with the hearing officer to provide counsel really about process. It came up at the hearing, the distinction between a hearing officer's function in an original application such as this one, where you have a special use permit being applied for, versus the hearing officer's function when the hearing officer serves essentially as an appellate body in a zoning interpretation. And yes, sometime almost immediately after the hearing, I spoke briefly with the hearing officer just to provide additional clarification regarding the distinction of the hearing officer's function in those two separate processes. There was no fact specific information or anything conveyed in that conversation. It was purely about the language of the Land Development Code and the hearing officer's role in those two separate processes. And it's not, it's not unusual for periodically, if there's process questions that happen between hearings or things, not actually between hearings, but between hearing dates, that sort of conversation can be had. But it was purely a procedural issue regarding the distinction between the hearing officer's role in an appeal, which would be the case, for example, as Tom spoke about with zoning interpretation, versus the hearing officer's function in an original application, like a special use or a variance.
Thank you.
All right, thank you, Mr. Clark. Okay, board members, this is the first time this case has appeared before us, so we have two available remedies. One is to affirm the decision of the land use hearing officer. The other option is to remand to the land use hearing officer, and if we do that, the rules require that we specify on what issues or topics why we're remanding and on what issues we believe the LUHO should further address. So let me open the floor to discussion. Well, let's do this. We need a motion before we have discussion. So the choices are to affirm the LUHO or to remand. So let's see if anybody's got a motion and see where that gets us. Vice Chair Bauman.
Mr. Chair, I'd like to make a motion to sustain the hearing officer's decision.
All right. Vice Chair Bauman has made a motion to approve the decision of the land use hearing officer. Is there a second to that motion?
I'll second it.
Motion is seconded.
I'll second that.
By Board Member Campbell. So we have a motion and a second to approve. I will do a roll call vote so that we can record everyone's vote, since some of our board members are not physically present. So the motion is to approve the decision of the land use hearing officer, Mr. Smith.
Would we not have some discussion at this point?
Yeah, go ahead. Would you like to discuss?
Yeah, I sense throughout the record that this communication issue resolved around the ability of the remote staff people to talk back and forth. I think that's something that's inherent in the technology that we're now working. I'm sitting many miles away from you. We're conversing. The system's getting better. And I just had a feeling that in the abundance of caution, the fact that if we do remand, we're asking the LUHO to consider whether or not she would approve of this development. If we send it, if it goes to the BOCC, they could defer it to a LUHO's decision for the same issue. I'm really at a loss as to why the appellant does not want to go get this blessing from the BOCC. And then in an abundance of caution, I would be somewhat in favor of having it remanded to the LUHO and specifically air out this issue, as it is so timely to this new technology that we're all suffering with. That's all the comment I would have.
All right, let's go through our other board members. If there's any further discussion, we should give everybody an opportunity. Board Member Schwartz, anything you would like to add to our conversation?
Nothing to add, no.
Board Member Cornelius.
Just briefly, Mr. Chair. I do agree with Mr. Smith and what he said. I do think it would be worthwhile for a fuller discussion at the LUHO. But I also do understand the position of the motion, and I am willing to support the motion.
All right, Board Member Campbell, any discussion?
No further discussion.
Vice Chair Batman, any further discussion?
No further discussion, Mr. Chair.
Let me just add, because Board Member Smith raised a point about the communication and some of those issues. I did not hear anybody say that whatever communication problems may have occurred prevented anybody from putting on their testimony or their evidence. So I don't really see that presents any reason to send it back. And I think Ms. Corbett has confirmed that she was given the opportunity to present whatever evidence she wanted. With that discussion now, let's go back to the motion, which is to approve the decision of the land use hearing officer. I'm going to do a roll call vote in the same order that we've been going. So on the motion to approve, Mr. Smith,
No.
Board Member Schwartz. Approve. Board Member Cornelius. Approve. Board Member Campbell.
Approve.
Vice Chair Bauman. Approve. And I vote to approve. And that shows us that the motion has passed by a vote of 5 yes and 1 no. So that concludes our proceedings on that case. I would suggest, since we've been going for a while, why don't we take a 10-minute recess before we call the next case, please? And so we'll be in recess for 10 minutes.
just to let the board know, the staff is ready. We're ready whenever you guys are.
All right, thank you for that. We are ready, so I will call the meeting back to order, or do we need a countdown?
Well, I'll count you in just 1 second. Attention, we are live in 3, 2, 1.
All right, thank you and welcome back. I will call back to order after a brief recess the December 4, 2020 meeting of the Hillsborough County Land Use Appeals Board. Ms. Rodriguez, would you call our next case, please?
Case is appeal number APP 20-1340. The petition file number is variance 20-0951. The appellant is Stephan W. and Marcella G. Price. The property owner is Stephan W. and Marcella G. Price. The representative is Ann Pollock with Fletcher Fisher Pollock PL. The petition request is to appeal the decision of the zoning hearing master who denied a variance for a third lot utilizing a septic tank in the urban service area. The location is 7205 Potts Road. The size of the property is 4 acres, more or less. The existing zone is ASC1, future land use RES4, service area urban, and the date of the hearing officer hearing was August 17, 2020.
All right, thank you, Ms. Rodriguez. Mr. Hisney, let's hear from staff on this one.
Just gave a thorough summary of the case, and I will be available for any questions from the board.
Okay. All right, so let's hear from the appellant.
Good afternoon, Ann Pollock with Fletcher Fisher Pollock Law Firm, 433 Central Avenue, St. Petersburg. As Ms. Rodriguez explained, I represent Stephan and Marcella Price, who owned the property at 7205 Potts Road. It's about 4 acres and has 2 homes on it that were constructed in 1972. It's zoned ASC1 and has a comp plan designation of Res 4, which both allow a density of 1 unit per acre. The property could be split into 3 lots, which is what the owners wish to do. 1 lot for each existing house and a 3rd lot with the remaining space available to build. The 2 existing homes each have their own septic system, but although the property otherwise meets all requirements for development of 3 lots, they were required to get a variance for the 3rd septic system. The LUHO denied this request, but that decision was an error. As I explained in great detail in the narrative submitted with this appeal, and as I'll discuss today, multiple findings of fact and conclusions of law in the decision of the LUHO to deny the variance are unsupported by competent substantial evidence as required by 11.04.02A2 of the Land Development Code. And additionally, the LUHO did not follow the essential requirements of the law. As such, this case should be remanded. The LUHO decision on whether the owner's hardship is unique and singular was based on the incorrect determination that the alleged hardship is the desire to build a 3rd home on the property. This determination is completely contrary to the evidence in the record. The fact that they wanted to do something with their property cannot in of itself be considered a hardship. Every need for a hardship starts with a request to do something. To decide the variance based on this erroneous determination is to go down the wrong path. It's the difficulty posed by the property's characteristics that are the hardship. The record reflects that the reason the property cannot be split into 3 lots is because of the wastewater requirements. The record reflects that the hardship they're dealing with is that public wastewater facilities are more than 1.25 miles away, 6,730 feet per county findings in the record. It's unavailable to them, and unavailable is not just an adjective to describe the service, it's a term of art that must be heeded. Both Comp Plan Policy 1.5 and Section 11.04.02 of the Land Development Code allow owners to request this variance to get a 3rd lot to use septic when there's a hardship. And Policy 1.5 allows a 3rd lot on septic in situations where reasonable use of the property would otherwise be unavailable. The definition of available public sewage or wastewater found in Section 381.0065 of Florida statutes is when the services are in a public easement or right-of-way that abuts the property, which clearly doesn't happen here. And I don't understand why in Riverview, in the middle of the urban service area, there's essentially a bubble around this property without wastewater service of at least a mile wide. But the fact is, connection to wastewater facilities is not available, and reasonable development of this property is not available because of it. There's also no competent substantial evidence to support the LUHO's determination that this is an issue of financial hardship. County staff recognize that service is not cost feasible, but there are no facts in the record to support a determination that the owners can't have public wastewater because they can't afford it. And more importantly, the comp plan does not say that reasonable use of the property requires the owners to bring wastewater service more than a mile to the property. The WUHO's determination that the property was not unique and singular was also not supported by competent substantial evidence. The fact that the property requires sewer service does not in and of itself make it the same as all the rest. The property is larger than many others in the immediate area, and that certainly makes it unique because it is a parent parcel large enough to be split, but is also out of no fault of its own in this small area of the urban service area that has no wastewater service available anywhere near. The owners cannot develop this property using the entitlements they have in a manner similar to the prevailing development pattern without this variance. The WUHO's incorrect assumption of what the hardship is also results in an incorrect determination of whether the literal requirements of the code deprive the owners of common rights and whether the substantial justice will be done by granting the variance. Again, the determination is not based in competent substantial evidence. First, as I mentioned before, the hardship is not the desire to have the third home. Such a determination means that no one could ever desire to do anything with their property that didn't fit perfectly into the rules. Second, the evidence in the record does not support the position that the owners have the ability to subdivide the property into 2 lots, much less that 2 lots is a, quote, reasonable use of the property, unquote. Instead, the evidence specifically identified the impossibility of subdividing the property into 2 lots and utilizing the entitlements allowed to the property. Third, the evidence in the record shows that the prevailing development pattern in the neighborhood is 1 to 2 acre lots, with 1 unit acre being allowed. The owners cannot develop similar to other properties in the area because it's infeasible and unreasonable to require them to get to an unavailable sewer system more than a mile away from the property to develop the land use entitlements they're already vested with. They're being deprived of common rights and will suffer substantial injustice if the variance denial is not remanded and overturned. Finally, there's no competent substantial evidence to support the LUHO's determination that the variance was not in harmony with the Land Development Code and the comp plan, merely because the comp plan says there's a clear intent to require development to connect to public sewer in the urban service area. No one's denying that. The staff addressed that overall intent of the comp plan, but there's no competent substantial evidence to support the position that this intent is applicable in all cases and cannot be waived upon good reason. The LUHO's determination that the county's desire to have suburban level development with wastewater connections in all cases, notwithstanding situations where flexibility is warranted and strict adherence to the plan is not possible, doing that would completely eliminate the value of the variance option that is specifically provided for in policy 1.5 of the comp plan. There's also no evidence in the record to support the LUHO's determination that it's a reasonable use of the property to develop at suburban level densities here. The comp plan and zoning allow 1 unit per acre density. To change this property to a more suburban level density would require both an amendment to the comp plan, an amendment to the rezoning, and a connection to the public wastewater service that's a mile away. But those changes aren't needed here, and they would be unreasonable to require because development of the property can be guided by the entitlements already approved under the comp plan and the zoning, and it meets the requirements for a third septic on the third lot under policy 1.5. Moreover, to value suburban level densities, but to deny the right to use entitlements allowing an extra unit here is contrary to comp plan policy 1.2, which, as was discussed in the record, supports the greatest density where possible. Development in Res 4, which is what this is mandated to occur at a density of at least 75% of the allowable density of the land use category. Development of this parcel with 3 lots would meet that 75% threshold and would be in harmony with the comp plan and the land development code. So I've given you a lot of examples here of where we feel the LUHO made determinations without competent substantial evidence, and that really should be sufficient to warrant the decision being remanded. But the LUHO's determination that the owners have no hardship because they wish to do something that is not otherwise allowed without a variance is also a violation of the essential requirements of law. The LUHO made several statements suggesting that developing the parcel into 2 lots was possible and reasonable, and that the request to create a 3rd lot is not a hardship. Variances provide flexibility in situations where the literal application of the code deprives the applicant of rights commonly enjoyed by others, where because of a hardship, the owners cannot make a change to their property that would otherwise be commonly allowed to do. Variances are about fairness and reasonableness given the case-by-case situation. In this case, a 3rd platted lot served by a septic tank system is prohibited unless there's a variance. But both the comp plan and the land development code allow that variance to be approved under appropriate circumstances. This variance process would not be available if the county had determined that no flexibility is ever warranted. By focusing only on the overriding goal of the applicants rather than the hardship that prohibits them from doing what is commonly enjoyed by others in this area, the LUHO has eliminated the essential purpose of the variance request. They've departed from the essential requirements of law. It's deprived the owners of a fair hearing in accordance with the land development code and the comp plan, and it's taken away the property rights. The LUHO's decision means the owners are bound to lose right from the start, and that's a clear violation of the essential requirements of law. So the LUHO's subjective determination of what is a hardship and what is a reasonable use of the property together, and whether the owners have met the criteria of the variance, without any competent substantial evidence to back up those assertions, and in violation of the essential requirements of law, leaves not only these owners in the lurch, but sets a precedent that no property owner in the county can meet such a hardship standard. As such, we respectfully request that this case be remanded for rehearing consistent with the code, the comp plan, and state law. Thank you very much. I'm here for questions.
All right, thank you, Ms. Pollack. Let me ask one question, and then I'll turn it over to our board members for their questions. You have spent some time explaining why you think the land use hearing officer did not get it right on the question of hardship. So articulate for us, please, exactly what you believe the hardship is in this case.
Hardship is the fact that the available wastewater service is more than a mile away.
Okay, and how is that unique and singular compared to everybody else in the same area who's got enough land for a 3rd lot, but no availability to a wastewater connection?
Because the availability, whether there's the amount of land to develop is not something that was of the record. In this case, they have a large lot that does have sufficient land to develop. But what was in the record was that surrounding properties are of 1 to 2 acres, not 4+ acres looking to develop further according to the entitlements that they are vested to. And because this property happens to be larger than others that were split previously, and therefore, they cannot reach the wastewater, that they are limited in developing the entitlements that they are vested to by the zoning and comp plan.
Let me clarify. I'm not sure you understood my question. We see these cases fairly regularly, and in every one of these cases seeking a 3rd lot on a well or septic, the property owner comes in and says, I have enough land to create my 3rd lot. I should be entitled to create my 3rd lot, and I've got the zoning to create my 3rd lot. I just don't have either water or wastewater available. That's the given fact pattern in every one of these, because frankly, if you didn't have enough land to build the 3rd lot, you won't be asking for the variance. So again, how is that set of facts, you have enough acreage to make a 3rd lot, but you don't have wastewater availability, any different than anybody else who's got a big lot in the same area?
think what the issue is not necessarily to just compare this to only other lots that have sufficient space to build a third lot. It's to look at all the other properties in the general area and what they are developed to, and what they have been allowed to develop to, which is to have 1 acre lots on their property. And the fact that there are large lots that are far away from wastewater, other areas of the county, does not necessarily mean that this is not something unique and singular to this area. In fact, this area is this strange bubble where there is no wastewater despite it being in the urban service area. And yet so many of the other properties in the surrounding area have already been split whatever time before and can develop that 1 acre lots, but we cannot.
Well, of the other 1 acre lots that you keep referring to, how many of them does the record show were subdivided third lots?
That was not discussed in the record, but that's certainly something that could be discussed if it were remanded for how this compares to other lots in the direct neighborhood location, the community where it's at.
All right, let me open it up to board member questions, and just to make this really exciting for everybody, I'm going to go in the opposite order this time. So let's start questions with Vice Chair Bauman. Any questions?
Yes, one. Thank you, Mr. Chair. Now, this property was already subdivided by having 2 different houses on well and septic on the property. Why should this be different with a third division?
I think there's some confusion in the facts. The property is one single parcel that has 2 houses on it. It's a non-conformity, but it was built, both houses were built back in 1972. So they are essentially a legal non-conformity because this was done before the code came into effect. So we would be splitting the property into 3 lots from the single lot that it is today in order to give one house, one lot, the second house, the second lot, and allow room for a third lot, third home. This would also clean up that nonconformity that is existing out there, that the code, of course, also suggests happen where you can.
Well, the reason is I'm looking on page 1B71. I see the 2 houses, one is to the left and one is to the center, but I don't see, other than maybe whatever the siting was back in the 1970s, but you've got 2 houses on well and septic, and the third house cannot be on well and septic without a variance. And in these somewhat rural areas of Hillsborough, that's fairly common. I don't see where.
This isn't really a rural area anymore. It's smack in the middle of the urban service area.
I know where it is. I'm a realtor. I know where it is. So my point is that there are many other homes in that area and other similar areas in the Eastern County, the North County, South County. But where is this specific hardship that no one else is actually encountering that impacts this?
I think it's incorrect to compare this to every other rural zoned or ASC zoned property in the county. The issue is to look at the community within which this property is located. It's located smack in the middle of the urban service area, but in an area where, even though subdivisions are around it, they are around it more than 1.5 miles away. And so as a result, no wastewater has been brought to this little area. And as a result of that, this little area, including properties like my clients, which happen to be big enough to split and develop in accordance with the development pattern of the community, which is about 1 acre lots, they are therefore stuck and cannot do anything any further. The comp plan does not, the comp plan looks at reasonable use of the property. It's reasonable use of the property to use the entitlements that meet virtually every single development standard. And it's a hardship that they cannot do that because they are limited by the fact that wastewater service is 1.5 miles away, 1.25 miles.
Okay, thank you.
All right, Board Member Campbell, any questions?
No questions.
Board Member Cornelius, any questions?
Yes, sir. Ms. Pollock, I hear from your argument or your testimony here, one of it, what I'm hearing is, well, the applicant should have the right to build out basically to the maximum they can under the adopted comp plan density of 1 unit per acre. My experience, and would you agree with this, is that the comp plan sets out your maximum potential, but doesn't guarantee you would get to that maximum based on other limitations, whether it's environmental or utilities. So would you agree with that statement that you're not guaranteed that maximum development potential, you're also limited by other factors?
That is certainly true, and that's why we're here requesting a variance, because we are limited by other factors. But I will state that in addition to the comp plan, the property is also in a zoning district that allows 1 unit per acre. So it's not just the future land use planning of the county to have this be an area where there's 1 acre lots, but the zoning has actually created a situation for this area with development standards that the applicant can meet, almost all of them, and that's how they want to move forward. So I think it's less sort of futuristic as to what the goal of the comp plan is for this area and more specific as to how the property is zoned, how all the other properties have been developed based on that same zoning, and what remains for this property.
But similarly with the zoning district, again, I would say, and again, do you agree here, that, I mean, that again is setting your maximum potential at the zoning level, subject to restrictions, and I agree with you saying that limitation is your septic, but, that is a limitation, as our other member said, is what many other properties in this area experience. I guess that's not so much a question as a statement. I apologize for that. But my second question would be, I believe in your testimony and in your write-up, you do make an argument to say, and again, I could be wrong here, so please correct me if I am, that it's not, splitting it into 2 is not reasonable, but splitting it into 3 is, and I don't understand that argument.
Well, there's a couple reasons. They had looked into originally splitting it into 2 using a certified parcel split application, which is an administrative process. Unfortunately, because of the way the property is designed and the homes on it are designed, the property cannot be split that way because it would require easements to get to the lot from the main road, Potts Road. So a subdivision would be required. So that's why they weren't splitting it. They did not decide to split it into 2 lots with 2 houses on one property and a new house on the other, given that they wanted to build a new house. Also because that would continue the nonconformity. In fact, expand the nonconformity by making the property smaller. So that's why they haven't been able to move forward. They weren't able to do 2 lots.
Okay, thank you. That's all I have, Mr. Chairman.
All right, Board Member Schwartz, any questions?
Just one, can you tell me about the access to these properties off of Potts Road? Is that a deeded easement that allows them to get to the homes?
As I discussed initially, because this property was originally developed in 1972, there are 2 homes on the one single parcel. And because there's 2 homes on the one single parcel, they don't need an easement, they just have a driveway. But were it to be split, they would of course have to follow subdivision rules and provide legal access. And it would likely have to be an easement access, and that would require the subdivision process, which is what we would like to go through.
Thank you.
All right, Board Member Smith, any questions?
Ms. Pollock, I think I heard you just say that they were not able to subdivide into 2 lots and retain the 2 houses on the original site and make that a non-conforming lot? You said they didn't want to?
They would like to build a third home on the property, but to split it into 2 lots and to have 1 lot service the new house and 1 lot service the other 2 houses, even though the other 2 houses have been on 1 lot for like 40 years, the county code does not allow that. It does not allow you to create a new lot that is non-conforming. So when we would go forward to subdivide, we would need to meet all the rules, including that you can only have 1 unit per lot. So that's why that's not possible.
Well, would that be possible and require a variance?
I don't know, but I think anyway, we would need the septic tank. So that obviously doesn't remove what we're here for today, because the septic tank would be needed for the new house. There's public water to the site, and there's septic for both of the existing houses. I would have to check with Mr. Hisney, but my understanding is that you could not have 2 houses on 1 lot just with a variance. That the whole thing would need to be rezoned. And that kind of gets back to one of the points I made, that yes, the county is ultimately looking to increase density. They would like to go to suburban level density, but to force it on this property is unreasonable and it's infeasible. And yet to suggest that we want more density, but we won't allow you to have the 3rd lot, that also is, counter to what they're trying to do, so.
Do you have a particular point to direct where the Luho has erred, or you just dispute her judgment?
I find that the decisions that she made based on the criteria that are required to be met, her decision has to be met with competent substantial evidence. And we do not believe that competent substantial evidence exists for those decisions. And as a result, the decision is in error. And since the process is to remand rather than overturn, we would ask that it be remanded and that we have a hearing where these issues could be discussed and she could create a new decision that would be solely based on the competent substantial evidence in the record. The determination she made seemed to come out of nowhere, and we feel that when you don't have the evidence to back up the determination is in error, and there should be a remand to have a new hearing to discuss it and make sure that her determination going forward is met with competent substantial evidence and does not violate the essential requirements of law in that she looks at what actually the hardship is.
Mr. Chair, this is Cameron Clark. May I interject?
Yes, please.
Just to clarify something, and I don't know if Ms. Pollock would want to speak to this, but just want to clarify that the burden is on the applicant to submit competent substantial evidence into the record that these 6 variance criteria are met. I just wanted to draw a distinction there because it sounded as though Ms. Pollock is stating that the hearing officer needs to submit competent substantial evidence denying any of the 6 criteria. The hearing officer obviously is not submitting evidence. They're making a finding on the evidence that is submitted. That's all I wanted to say.
All right, thank you. I appreciate that clarification. Ms. Pollock, let's see if there is any opposition first of all. If so, we'll hear from any opposition, and then we'll hear from Mr. Hisney. So do we have any opposition on this case?
No one is present.
No opposition?
No, sir.
All right, then Mr. Hisney, what does the staff have to say about this?
I don't have anything to add, but I am available for questions you may have.
I've got a couple of questions. We have seen a number of this type of variance request in our last several meetings. My recollection may be imperfect, but this is I think is the first one that I can remember where the property is within the urban service area, and yet does not have either water or wastewater service available. Does that make any difference here in terms of the staff's position?
Any case that you've seen concerning this, the property would be in the urban service area, because properties that are located in the rural area are free to use septic tanks subject to lot size requirements, and in fact you cannot extend public services into the rural area. So any case that's come before you on appeal for a variance regarding a third lot on septic, which is what you would see, is in the urban service area, and in those cases, the rule in the urban service area, what's called the standard level of service, is that new development shall connect to public water and public sewer. The code historically and presently does provide limited exceptions to that. But those exceptions are predicated on that connection to public water and or public sewer is not cost feasible per some technical tables. And in those cases, a property could be split into two lots by right, subject to the zoning requirements, etc. But again, provided that connection is not cost feasible per the technical manual of the code, not per a property owner's bank account or desires. In this case, public water actually is available and would have to be utilized for the subdivision. So in this case, they're only asking so by right you could do two lots, and then the code says you can ask for a variance to go to three. And in this case, that's what's happening with the wastewater connection. It is not cost feasible to connect for two or three lots, which then allows them to request a variance. If it was cost feasible, then they would not even be able to ask for a variance. They would have to connect.
Okay. Let me see if any other board members have questions for Mr. Hisney. Same order, Vice Chair Bauman, any questions?
No questions, Mr. Chair.
Board Member Campbell, any questions?
This is my first year, so I've not heard any of these before. As I've read through this, it seems that the appellant is willing to comply with the standard, which is 1 unit per acre, and has the room there to do it. There is a variance process in place. They're in the urban service area, but they cannot be, the county has not provided the connection. It just seems to me that the variance is the way to go, and for most of the arguments that the appellant made, I find it difficult to understand how you would take exception to those. But again, this is the first one I'm hearing, but that's just the way I'm leaning.
Anything to add on that, Mr. Hisney?
Well, let me clarify that staff, unlike the last appeal, which was a special use, and staff makes a recommendation in variances, staff makes no recommendation whatsoever. Our role in variances is simply to identify the applicable regulations and then identify the variance that's requested by the applicant. It's entirely up to the applicant to convince the hearing officer to grant it. So we do not make a recommendation in any manner on variances.
Thank you. I find that very helpful.
All right, Mr. Hisney, if you would, you touched on this briefly, I think, in your comments, but maybe you could expand a bit. In this situation, the code essentially allows a lot owner to split into two lots as of right, provided the other criteria are met, but then requires a variance for any further carve out to a third lot. What's the underlying policy that the code is concerned with there?
Really, the reason the rule is in place about that the standard level of service in the urban development area is connection to public water and wastewater was what was discussed during the hearing, is that the county has a combat urban growth policy in which they want to maximize densities within the urban area, the urban service area, and it was found that in the past when there weren't regulations limiting. Now, in connection with that, presently, public services are not available throughout the urban service area. So the county wants to concentrate growth in there, but in fact, urban services are not available throughout the urban service area or public services. So the regulation was put, so in the past, there would be times when, let's say, a large piece of property was divided into maybe 10 lots, all on 10 1-acre lots or 10 half-acre lots on septic tanks because connection to public water wasn't available. The problem with that is that when that occurs, that would become essentially a permanent development pattern, and it would be at a density that's below what's really desired and planned in the urban service area, which is 4 or 6 units an acre or more. And so some years ago, the plan was changed and the regulations were put in the code to try to discourage that while still allowing for a small increase in the development of a piece of property. And that's why the code allows you to split into 2 so you can divide it somewhat. And provides a variance for 3. And again, all of this contingent upon that connection is not cost feasible to the public services. So it's trying to balance the interest of the county to preserve properties for suburban or even urban level development while still providing an incremental development opportunity for the property owner in cases where, again, the public services are not available.
Thank you. Let's go to the rest of our board members. Board Member Cornelius, any questions?
No, sir.
Board Member Schwartz, any questions?
Yes, I have one. Could you explain to me why couldn't this property be divided into 3 lots and a septic tank put in for that 3rd lot?
Are you asking me, sir, or the applicant?
Yes, you.
Well, because the code requires that you have to have approval of a variance for a 3rd lot on septic. So that's what prevents them from doing it by right. They're not they're not allowed to do it by right. They could split it into 2 lots by right, but they cannot split into 3 without approval of the variance.
I guess my question is there any problem with the variance being approved?
For the land use hearing officer and your board to decide, sir. Again, our staff makes no recommendations whatsoever on variances.
All right, thank you.
And Board Member Smith, any questions?
I recall some of the other cases similar to this, and the economic factor was debated at quite a length, and I'm not so sure, but in this record, it indicates that the economic factor, no matter what the cost, cannot be entered as a valid justification of a variance. And I was trying to find where that was, because when did that get established as such a hardline fact?
Yes, Mr. Smith, this is Cameron Clark. I can speak to that. There's case law in Florida stating that economic hardship alone cannot justify variance criteria. So simply that it is somehow expensive to follow a criteria required by the Land Development Code is not sufficient reason for it to get a variance. The uniqueness standards and other criteria that are in the 6 variance criteria are what we have to follow under the LDC. And there are cases that have stated that economic hardship alone cannot justify the variance approval.
All right, any other questions, Board Member Smith?
I'm just still puzzling over Mr. Hisney did say that if you, in the situation that this appeal comes to us, that they have the right to bring it forward for a decision because of the non-availability of public services. But that's all they have, is the right to ask for a variance. And then the fact that it's so far away and so much of a cost, that eliminates the need for the variance. I'm kind of like caught in a hard place here between those two situations. That if the fact that it's so far away justifies asking for a variance, but don't bother asking because the fact it's so far away and costs so much money won't count. It's a puzzlement.
Mr. Clark, you want to add anything on that?
No, sir. Just to state that the uniqueness standard that the code looks at regards uniqueness of the property. So, I mean, not in this instance necessarily, but I'm just giving a sort of a vague example. If the shape of a lot is unusual and it doesn't match surrounding lots, and it prevents something, I'm going to give setbacks as an example. You couldn't actually build a comparable structure on that lot without encroaching into a setback, then it's really the unique shape of that property that's at issue. I think that what's at issue here, as far as the distance, the hearing officer made a determination as far as the various variance criteria that there was not competent substantial evidence to justify the variance, and this board's function is to take a look at the hearing officer's decision and determine if in fact the board feels that there was competent substantial evidence or wants further explanation as to the decision. The board can remand it. If the board does not find any of those things, then the board can uphold the hearing officer's denial.
All right, thank you. Board Member Smith, any further questions?
No.
All right. Ms. Pollack, there's no opposition, but after you presented, Mr. Hisney had some comments, so I'll give you an opportunity for just a couple of minutes of rebuttal if you feel so inclined.
I'd just like to hit a couple points. One that Mr. Clark said, we absolutely feel there's substantial competent evidence in the record to support our position that there is a hardship, that we are unique and a unique property, that we are in harmony with the land development code and the comp plan, and that substantial justice will be done by granting this variance, and that the literal requirements of the code do deprive the owners of common rights. And I believe I've addressed all those here. The variance code 11.04.02A2 provides that each finding of fact of the variance of the LUHO shall be supported by substantial evidence in the record. The findings of fact of the LUHO were not supported by substantial competent evidence. That is the decision that you're making here today. That's the decision of whether we should remand. I personally, and we feel we had substantial evidence to support our position, and we brought that evidence to the record, to the hearing, absolutely as is required. But in making a determination, the LUHO has to make findings of fact that are indeed based on substantial competent evidence in the record, and that was not done in this case. I also think the issue of what the hardship is important. The hearing officer made a comment about that the owners don't need a third house. And that is not something that is based on competent substantial evidence. That is a personal determination that they don't need a third house, that they're good enough. 2 is fine. You're good enough, just take it or leave it. That is an inappropriate look at how this variance is supposed to be looked at. That is why it is a violation of the essential requirements of law to do what has been done in this case. And why looking at the actual hardship and making a determination based on that and finding competent substantial evidence in the record to back up that determination is what we are asking this to be remanded in order to do. I wanted to hit about the issue of cost. Well, you know, I wanted to hit one other issue, which was the issue of density. And yes, this is indeed in the urban service area. Not every area of the urban service area has septic service. And indeed, the county made a determination in the record that it would be cost infeasible to get wastewater service, public wastewater service. But the comp plan, in fact, does want increased density, even in these Res 4 districts designations where the density is 1 unit per acre, which really is not a suburban level density that ultimately the county wants to have across the board in the urban service area. That's going to take a very long time, given the land use designations and the zoning designations that these properties are already vested with. And because the comp plan has made a determination that for these kinds of areas where the density is 1 unit per acre, they want to encourage 75% of those properties to be developed. And that is exactly what this would do. So I think I've pretty clearly stated that the reasons why there is substantial evidence to support our position, why there is not substantial evidence to support the Lujo's opinion, and I would respectfully request that this be remanded.
Thank you, Ms. Pollock.
Mr. Chair, this is Cameron Clark. May I speak again?
Yes.
I just want to add a little context, because I don't want to get bogged down in semantics, with respect to what Ms. Pollock is stating, but 110402 regarding the required findings and conditions for a variance. 110402A1 reads, a variance may only be allowed by the LUHO in cases involving practical difficulties or unnecessary hardship when substantial evidence in the official record of the hearing supports specific findings. Part 2, all findings of fact shall be made in the indicated order by the LUHO, which is not empowered to grant a variance without an affirmative finding of fact.
Mr. Clerk, we're having some issues with your microphone there.
Okay.
It's sounding like static.
Can you get it now? Anything now?
We're getting clicking now.
How about now?
It's lower.
Testing.
Okay, I think we're a little better there.
Can everybody hear me, Mr. Chair? Board members, can you hear me?
I can hear you, Mr. Clark. Go ahead.
Okay, so just to touch on the last part, all findings of fact, this is by the hearing officer, shall be made in the indicated order by the LUHO, which is not empowered to grant a variance without an affirmative finding of fact in all 6 categories, 110402B below. Then it says each finding of fact should be supported by substantial evidence in the record. I read that statement to mean the hearing officer is not empowered to grant the variance unless they've made an affirmative finding of fact that competent substantial evidence exists to support each of the 6 criteria. I think my only concern about the phrasing that Ms. Pollock has used is, in an instance where a hearing officer finds that there is not competent substantial evidence in the record to support 1 or more of the 6 criteria, the hearing officer is not empowered to grant the variance. I think it's the wording that I object to, is to say, well, the hearing officer has to submit competent substantial evidence that the applicant did not submit competent substantial evidence. The hearing officer is not submitting evidence. They're making a ruling on the evidence that was submitted by the applicant. And so a hearing officer's opinion and ruling in the case of a denial is going to be whether or not the applicant submitted such evidence, because the hearing officer is not allowed to grant a variance unless such evidence was entered into the official record.
Yeah, I think we're clear on that. The hearing officer makes a decision and we then review it based on the record that was created below. I don't think anybody thinks the hearing officer has any burden to put on evidence in the case. So I think we're all clear on that, but thank you for making sure that we're all clear on it. So we've heard from everybody we're going to hear from. If somebody, again, this is the first time for this case before us, so our options are approve the Lujo's decision or remand it. If we remand, we should specify why and which of the 6 variance criteria we believe the Lujo got wrong, so the Lujo knows what to do on a remand. So we're at the point in the proceedings where if there's a motion, I will entertain it. And for my benefit, if you have a motion, raise your hand. Vice Chair Bauman, go ahead.
Mr. Chair, I make a motion to approve the Lujo's decision.
Vice Chair Bauman has made a motion to approve the decision of the Lujo. Is there a second?
Chairman, I'll second. Brad Cornelius.
Seconded by Mr. Cornelius. So we have a motion and a second. Let's see if there's any further discussion. Board Member Smith, any discussion on the motion?
Well, I feel that there's something different in this parcel that might make it unique. The fact that we've got 2 houses there that are legal non-conforming, and somewhere in the passage of time, the county puts that into an urban service area and throws back this new requirement on that existing parcel that now it cannot be met with a variance. I'm just puzzled by that, and I would think that this particular site might be unique and different because of that. Anyway, that's just for public or board discussion. I throw that out there. The other thing is the Lujo was no on 2 of the 6 items, but I believe if you could find that there is some unique difference, then the no to number 6 would also go away.
Okay, thank you. Board Member Schwartz, any discussion?
I was just wondering, was there ever a site plan submitted with the split for 3 proposed division in the 3 lots?
It was not, because the process for splitting it into 3 lots would be to request a subdivision, and you would get a surveyor, you would pay a surveyor to do a plat, a preliminary plat. But as part of the subdivision review, the county would look at whether the infrastructure is there to provide the utility services. So one of the questions they would look at would be, what are you going to do with your wastewater? And at that point, they'd say, well, you don't have public wastewater. You need to either get it or you need to get a 3rd septic through a variance. So we just skipped that whole discussion and came straight to the request for the variance first, because we knew that is the one thing holding up the split of this property. It meets every other criteria, and but for the fact of the layout of the property and really this wastewater issue, that's the only thing holding it up.
Okay, thank you, Ms. Pollock. Anything else, Mr. Schwartz?
No, that's it.
Board Member Cornelius, any discussion?
Mr. Chairman, just very briefly, in review of the Lujo's findings, I fully support her findings and believe she had made the appropriate decision on the evidence she had before her. That's all I have to say, sir.
All right, thank you. Board Member Campbell, any discussion?
No discussion.
And Vice Chair Bauman, any discussion?
No discussion, Mr. Chair.
All right, I don't have anything to add beyond what has already been said, so I will call the motion. The motion is to approve the decision of the land use hearing officer. If each board member, when I call your name, would indicate yes or no on the motion. Board Member Smith?
No.
Board Member Schwartz?
No.
Board Member Cornelius?
Yes.
Board Member Campbell?
No.
Vice Chair Bauman?
Yes.
And I'm a yes. And we have a tie. Mr. Clark, the result of a tie vote is what?
The result of a tie vote would be the motion fails. So we would need a new motion or a continuance of the item to get to an additional board member, so you have an odd number.
Right. I feel like we've done this recently on another case. So let me recap. We had a motion to approve that ended up with a vote of 3-3. So that motion failed. The only other possible motion that could be made is a motion to remand. And if somebody makes that motion and there's a second, we'll vote on that. So if anybody wishes to make a motion to remand, this would be the time to do that.
Make a motion.
And who was that? Board Member Schwartz has made a motion to remand. Now, you'll have to tell us on what basis you want to remand, and we have to specify why we're remanding, so the hearing officer knows what to do.
I feel that they should be given an opportunity to submit the plans. I feel that they should be given the opportunity to go back and submit their plans for dividing into 3. If they get approval, fine. If they don't get approval, but I think they should be given that opportunity to do so.
All right, so we have a motion to remand. Is there a second?
Well, I would vote or second to remand, but I think we'd have to be a bit more specific on item 1 as to what is unique and singular about the property. And I still think that there's some value in the fact that no control of this owner, the county put it in an urban service area, which imported onto it this extra dimension that cannot seem to be met without a variance. And the fact that you, go ahead.
Hang on, Mr. Smith. There's a motion on the floor. If you want to second that motion, you're entitled to do that. If you want to change that motion, then we're going to have to talk about a motion to amend it. But the issue right now is there a second for the motion that we have?
Mr. Chairman, I don't know if it's a clarification on the proposed vote here, or it's just to clarify. I would say that the hearing officer, this should be remanded back to the hearing officer because they did not fully evaluate the substantial competent evidence or the variance under the findings of fact for areas 1, 2, 4, and 6.
All right, let's do this. That's a little more specific. So Board Member Schwartz, would you accept that as an amendment to your motion?
Yes, I do.
All right, so as amended, is there a second for the motion?
I would second that.
All right, so now we have a motion as amended and a second by Board Member Smith. It's kind of the flip side of the coin of the first motion, so I don't know that we need a whole lot more discussion. So let's go to a vote. Oh, Vice Chair Bauman, go ahead.
My discussion is that it's just my opinion that Attorney Pollack, in talking about the subdivision process, is taking an end run around the land use hearing officer, because there is a process to divide this property into 3 lots. There was a discussion by Ms. Pollack about an easement. I don't see the easement appearing on the schematic, where it is, how it is, but clearly there is some kind of easement issue of Patch Road between the 2 houses and a possible 3rd house. The proper procedure would have been to put in a subdivision request to divide this into 3 separate lots, where each would have been 1 acre or more, that would have conformed to the urban process, and that would have made sense. But no, it's the quick and easy way, just come and ask for the variance. That's the issue that I have in sending it back to the land use hearing officer, because I don't see where the land use hearing officer misapplied any of the criteria.
Okay. Let me look around our side of the room here. Any other discussion at the board member level? Board member Smith, anything further before we call the vote?
No.
All right, so on the motion, which is to remand as to variance criteria number 1, number 2, number 4, and number 6. I'll call the roll. Please indicate yes or no on the motion to remand. Board member Smith.
Yes.
Board member Schwartz.
Yes.
Board member Cornelius.
No.
Board member Campbell.
Yes.
Vice Chair Bauman.
No.
And I'm a no, which means we end up tied again. So that motion fails. If I counted that correctly. I think I did. All right, so we've had a motion to approve the LUMO, which failed on a tie vote. We had a motion to remand, which failed on a tie vote. We don't have any other options. So, Mr. Clark, what do we do?
Mr. Chair, I haven't seen this happen before. I don't think you have either in our years doing this. I think the only option at this point is to continue the appeal to the next LUAB date, and we would need a full board.
Right.
For what it's worth, the problem too is you would really, for the benefit of the additional member, we would need a complete rehearing of the case. It wouldn't just be a re-vote. Obviously, the additional
Right.
to hear the entire application again.
All right, well, all we can do is what we can do with the board members that we have in attendance whenever we meet, so I think the only thing we can do at this point.
And there are only 6 of you right now. We do have one alternate, but she has not been very responsive to anything. So right now, you do have a full board sitting right there until we recruit another member.
All right. Well, that's not helpful at all. I say that in jest for people watching at home. So we're not going to get any more board members at another meeting, is what I hear you telling us.
The applicant would like to speak.
Okay.
Go ahead.
I was just hoping I could have the opportunity to respond to Ms. Bauman's comment about the subdivision.
No, we're not going to hear any more argument. We've already voted twice. There's no point in more argument. So we are stymied at this point, and we don't have any other options. So the only thing I can think to do is continue the case to our next meeting and see if anything different happens. Is there a motion to continue the case?
Motion.
Who made that motion?
Motion to continue the case.
All right, we have a motion. Is there a second?
Mr. Chairman, I'll second.
Seconded to continue. So on the motion to continue, Vice Chair Bauman?
Yes.
Yes?
Yes.
Board Member Campbell?
Yes.
Board Member Cornelius?
Yes.
Board Member Schwartz?
Yes.
Board Member Smith?
Well, I'm affirmative, but would you want to put in there to continue it until a time when you have an odd number of board?
No, because we can't control that. We'll just continue it to the next meeting and see what happens. And so are you a yes?
Yes.
And I'm a yes, so the motion to continue carries unanimously. So that case will be carried over to our next meeting. And that's all we can do with that one for today.
Mr. Chair, who made the motion in the second?
Vice Chair Bauman made the motion to continue, and who was the second? Was Board Member Cornelius.
All right, thank you, sir.
All right, so that case is concluded for today. The only other thing I see on the agenda is that we have some minutes to approve. Is there a motion to approve the February 7, 2020 minutes?
Motion to approve, Mr. Chair.
Vice Chair Bauman moves to approve. Is there a second? Second? Seconded by Board Member Schwartz. Let's go roll call on the minutes, February 7 to approve. Board Member Smith?
Yes.
Board Member Schwartz?
Yes.
Board Member Cornelius?
Yes.
Board Member Campbell?
Yes.
Vice Chair Bauman?
Yes.
And I'm a yes. The minutes are approved, 6-0. I believe that is all we have on our agenda. Ms. Rodriguez, do we have a meeting in January?
Not as of yet. As soon as we, lock down a date, I'll certainly inform everyone.
All right. Any other business to come before us today that we have?
Mr. Chair?
Yes.
Did we approve the September 4th minutes as well?
Are there more minutes? Oh. All right, very good. We have minutes of September 4, 2020. Is there a motion to approve?
Motion to approve September minutes, Mr. Chair.
Vice Chair Bauman, is there a second?
A second.
Yes, hang on.
Seconded by Board Member Smith. To approve the minutes, let's do roll call. Mr. Smith?
Yes.
Mr. Schwartz?
Yes.
Mr. Cornelius?
Yes.
Mr. Campbell?
Yes.
Ms. Bauman?
Yes.
And I'm a yes. The minutes are approved, 6-0.
Mr. Chair, this is Cameron Clark. One more quick question, may I?
Go ahead.
Yeah, I believe I just heard staff state there's no hearings for the January date. However, did the board not just continue the second application today to that date?
Right. So apparently there is a meeting. I think what Ms. Rodriguez was telling us is that we just don't have a date yet.
Okay, understood. Thank you so much.
So we have a case, Ms. Rodriguez, because we just continued the second case. You will let us know when that meeting's going to occur?
Yes, sir. As soon as, we're able to start scheduling. Right now, the scheduling is on hold.
All right. When do we think we're going to know? Because we all have other lives.
And I understand. It should be again sometime this month.
All right. All right. I think that's all we have for this board today. Thanks everyone for participating. County staff on the technology side, thank you very much. All of you did a great job, and the meeting is adjourned.